Yes, am I audible? Okay, so the agenda for today, let me start with the class. The agenda will be, I hope you would have revised the 4 units of Indian Contract Act. That's why I gave you 1 day's time. Yesterday was the 1 day time to learn and watch the videos. So unit 4, unit 5 and unit 6. So we'll be discussing performance of contract, then breach of contract and remedies, and then quasi contract and contingent contract. Now, fairly simple. I've explained all these concepts in the video. So quickly, let's start with the questions. So let us first take up. Yeah, you can open. We'll go in reverse order. So we will first finish unit 6, then we will go to unit 5, then we will go to unit 4. Fairly simple chapters. Unit 4 is a little big, but unit 5 and unit 6 are small ones. So let's start with unit 6. Let me present the questions. So what we'll do, I'll give you all 2 minutes time. Go through the first 10 true or false questions and let us discuss them. Any issues, you can always type in the chat. Anu, you have a doubt in yesterday's question paper. Which question paper? You can just type it out which question, or you can WhatsApp me. I'll sort it out. Last 30 seconds, guys. Then we'll start discussing the questions. Okay, let's start discussing, guys. Question: Who can read today? Anybody? Guys, who can read? Anyone? Hello. Any volunteers to read? Yeah. Okay. I'll just unmute. Anu, she asked. Anu, you can unmute yourself and we can start discussing.
Yes, sir.
Yeah. Read the first question.
A finder of lost goods is just like a bailee.
Answer.
True.
Yeah, it is true. Finder of lost goods is just like a bailee. Who
Just
is a
like a bailee.
bailee? In depth, who's a bailer and bailee? Fairly simple. If I can give you a CA interview if you want, but see, bailer is a person. Now, let's say, for example, you are giving your pen drive to your friend. He wants to use it for 1 week because he has a project. Now, in this case, bailer is the person who is giving the pen drive. Bailee is the person who is taking the pen drive. Now, when you give your pen drive to your friend, what is his responsibility? His responsibility is to return it back to you in the same condition you gave it. Can your friend say the pen drive is broken now? No. If he breaks it, he has to pay for it. So, Bailee is somebody who is keeping possession of goods on behalf of somebody else for a specific purpose, and he has to return the goods back to the bailer. Therefore, finder of lost goods is just like a bailee. First answer is true. Second question, read it, no?
A miner is personally responsible for necessaries supplied to his dependent.
Answer.
Sir, I didn't understand this. To his dependent.
Dependent means say of parents, elder brother, and all of that. People who are dependent on the minor. So what they're saying is, somebody's, let's say minor has another brother. Somebody is supplying goods to the minor's dependent. They're asking if minor is personally responsible. No, minor can never
Oh
be
no,
personally
please.
responsible. Therefore, answer is false. Only the personal property of the
False.
minor will be responsible. Third one. Can you read the third question for us?
An agreement void ab initio cannot be a quasi contract.
Answer.
True, I prefer, sir.
Yeah, third one is true. See, the minute void ab initio comes, once an agreement is void, then the agreement will never be a contract. You're calling something a contract over here. They're saying agreement, void ab initio
Yes.
cannot be a quasi contract. Yes, it cannot be a quasi contract. So answer is true.
True.
Next, fourth one.
The finder of goods may sue the owner for a specific award, if any, offered by the owner.
Answer for D.
Finder of goods may sue the owner for a specific award. So can you explain the question?
Yeah, see. Now let's say there is a house. Let's say Mr. X has a dog. His dog got lost. So he's putting a missing pamphlet. Whoever finds the dog, I will give them 5,000 rupees reward. Now, Mr. Y saw this pamphlet on the road. Then he saw the dog also in a nearby street. He took the dog and he went and gave it to X. Now X is saying, no, 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 I will not give you 5,000 rupees. Now read the words. The finder of goods here, Y,
Yes.
may sue the owner for
Sue the
specific
owner.
award if
What?
any
Any
offered by
offer
the
by
owner.
the
Who is the
Yes,
owner here?
true, sir.
X is offering the award. Since
Yes.
he is offered the award and Y knows it, he can sue him for the
Soon.
specific award.
Yes,
Therefore,
true,
answer
sir.
for D is true.
True.
Many of you have given me false. Kriti, Saidarni, then Pratham, they've all given me false. So the answer for question number 4 is true. Very simple, guys. Let me explain again quickly. Let's say X is the owner of a dog. He has a dog. His dog got lost. So he's putting up, you have seen many missing pamphlets. Find the missing dog, 5,000 rupees reward. So Y found this dog after seeing this pamphlet. So now he is going to X and giving his dog and asking for the 5,000 rupees amount. X is saying, no, I will not make the payment. Now the question is, can Y sue X? So finder of lost goods may sue the owner for a specific award. What is specific award here? 5,000. If it is offered by the owner, it is offered by the owner, therefore he can sue it. Second case, what if 5,000 is not mentioned here? They just told dog is missing, can you please find the dog? Then Y will go and return it. He cannot ask any money unless X gives any money on his own. Next, point number 5. Read it for us.
A person cannot recover from another an amount paid under a mistake of law.
Answer.
It is false.
Others answer for question number 5. It is false. One of the quasi contract, last quasi contract says payment of money which you received by mistake. I'll give you a coercion or mistake, you have to return it. I'll give you a simple example, classic example for this. Let us say all of you have a bank account, correct? All of you have a bank account, or even if you don't have, let's say you have a parent's bank account. Tomorrow morning, suddenly you are seeing 10 crores deposited in your account, credit. Somebody by mistake, instead of transferring to let's say 785 account, they transfer to 786, 10 crores rupees. Luckily, you got 10 crores when you woke up. Immediately, you withdrew the entire money and you kept it in your house. Now, the bank is calling you and saying, sir, we transferred the money to you by mistake. You have to return it back. Can you please return it? What should you do? You have to say yes and you will return it. Can you say, no, 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 money came to my account. It belongs to me. Now I will not give it back. Obviously not, right? Logically, you will give the money back, right? So that is the concept here. A person can recover from another amount paid under mistake of law. Sorry, mistake of law. So mistake of law or mistake of fact, any mistake, if you're paying, then you have to pay the money. Understood, guys? Question number 5 is false. Question number 6.
The event in a contingent contract may be certain or uncertain.
Answer.
It is true.
I'm getting people saying true, guys? Again, think, guys. See, only Soumya got the correct answer. Others answer is false, not true, guys. Just think about it. The event in a contingent contract has to be uncertain. It cannot be certain. Read the definition. Read the definition for contingent contract. Contingent contract. If you see the video, the first part of the video itself for Unit 6, I have explained the definition of contingent contract. Contingent contract is a contract where any event collateral to the contract. Main term over there is uncertain event. Therefore, answer is false for question number 6. Good. Yeah. So Saidharni Ilavarsi, good. Correct answer. Gaurav also. Gaurav, someone. Yeah. Correct answer. Okay. Kriti, correct. Next. G. Read the G question for us.
The performance of a contingent contract must not depend upon mere will of the promisor.
Answer.
It is true.
So one of the rules of contingent contract, if you see, now the performance of the contingent contract must not depend upon the mere will of the promisor. So let's say X is telling Y, if it rains tomorrow, I'll pay you 100 rupees. If it does not rain, I won't pay you anything. Y will not pay X anything back. See, it is called betting. If Y will pay anything back to X, here he will not pay anything back to X. X is just telling Y, if it rains, I'll give you 100. If it does not rain, I won't give you any money. Now, whether rain happens or not, whose control is it in? Can X control the rain? No. So the performance of contingent contract, performance here, raining, must not depend on the mere will of the promisor. So it is not an X's control. Therefore, it is true. Contingent contract's essential nature is the performance of contract should not depend on the parties. It should be outside uncertain, not in their control. So answer for G is true. Next, read H, no?
The performance of a contingent contract depends upon the happening of some future event.
Answer.
It is false.
Answer is false. See, read the wordings very carefully, guys. Ahia got it correct. The performance of contingent contract depends upon happening. The correct statement is depends upon happening or not happening of a future event. Depends upon happening or not happening of a future event. Now, if you see carefully, I can say if it rains, I will pay you 100, or if it does not rain, I'll pay you 100. So the event can be happening or non happening. It can be anything based on the contract. So not only about the happening. Therefore, answer is false for H. Read I, no? Hello?
Sir?
Yeah, can you read question number I?
Yes, sir. Quasi contracts and contingent contracts are opposite to each other.
Answer, Anu, can you give me the answer?
Uh,
I'm getting correct answers from Saidarni,
I
Gaurav, Soumya, correct. Kriti, Darshita, correct. Your answer, Anu?
is it false?
Correct. Answer is false. Very simple, guys. See, I know you're not confident, but just think conceptually. Quasi contract and contingent contract are two different concepts, two unique and different concepts, correct?
Yes,
There
sir.
is separate unit 6, two different separate concepts. There is no relationship between contingent contract and quasi contract. The only relationship is it is there in the same chapter in textbook. That's all, nothing else. Both are separate concepts. Therefore, it is not opposite to each other. It is very different concepts. Next.
The event in a contingent contract must be essential to the contract.
Answer.
Event in a contingent contract must be essential. So is it false?
Yeah, it is false. Look at the wordings. Event in contingent contract must be collateral. The
Yes, sir.
wordings they use is collateral. Correct? If you see textbook, it is collateral. It
Yes.
is not contingent. Clear, guys? So this is the answer for all the 10 MCQs. Any doubts in any MCQs before I proceed to next question? Okay, so fairly simple MCQs. Let me proceed. Yeah, Anu, you can mute yourself.
Yes, sir.
Yeah, okay. Anybody else who wants to talk next, like who wants to participate? Yeah, Darshita, I've unmuted you. You can.
Yes, sir.
So
Just
question number, yeah, just one second. Question number 2 is fairly simple. Let's not discuss that. It's a straightforward textbook question. Explain the meaning of quasi contract. I explained conceptually what is there in the video. Textbook, there are points. State the circumstances which are identified as quasi contract. Those 5 points from section 69 to 73. You have to write all the points. Payment made under mistake, all those straightforward. It's a direct question, so nothing much to discuss over here. Concepts, what is quasi contract? I have discussed in the video very clearly. Any specific point, any specific issue in quasi contract, sir, I have doubt in this particular point, you can please type or raise your hand. I will explain it again over here. Not an issue. Next, Darshita, you can read 3 and 4 for us.
sir, I think 3 is incomplete. Left his carriage on these premises.
I'll just tell you, it is 1 second.
Yeah.
Just type P left his carriage on these premises.
Okay, sir. P left his carriage on these premises and these landlords seized the carriage for non-payment of the rent. P paid the rent to obtain the release of his carriage. Could P recover the amount from the... yes, sir, he can.
Yeah, so answer is yes, he can. Others take a minute time. Basically, what they're saying is P left his luggage, like his goods or whatever, on these premises. These landlords seized the carriage because non-payment of rent. Now, instead of, so P paid his rent to obtain his goods. Can P recover the amount from D? Absolutely yes. Because who is supposed to pay the rent? D should only pay it. P paid on behalf of D. Concept of payment made by interested person under quasi contract. Payment made by interested person. That is the
So is
concept.
it section 69?
Yes. Next, can you read the next question?
Sir, I have a doubt. Is this section 69?
Sorry, I can't hear you. Once again.
Is this section 69 of the quasi contract? Reimbursement of the money paid.
Yeah, payment made to interested person. Yes.
Okay. Fourth question. X supplied rice and wheat worth rupees 20,000. Y supplied a mobile phone worth rupees 30,000. And Z lent rupees 50,000 for the purchase of necessaries to the wife and children of M, a minor. M had assets worth rupees 1 lakh. Can X, Y, and Z recover anything from M?
Others go through, guys. So again, this is again from quasi contract, guys. The very first concept of quasi contract. This is section 68. But I don't want to refer the provision. Just see the concept. This combination of minor exceptions, but the provision comes from here only.
X and Z can recover the money from M.
Yeah, they can recover. The concept is when you are supplying necessities to a person who's incapable to enter into a contract. One of the person who's incapable to enter, look at this, X supply, no, look at this carefully, guys. X supplied rice and wheat worth of 20,000. Y supplied a mobile phone worth 30,000. And Z lent rupees 50,000 for purchase of necessities for the wife of to the wife and children of M, a minor. Now, M has assets worth 1 lakh. Can X, Y, and Z recover from M? Now, you have to see when you supply necessities to people incapable of entering into a contract, only for necessities you can recover. Now, X is supplying rice and wheat. Are they necessities? Yes. Therefore, X can recover from the personal property. He cannot recover from the minor itself, from the property belonging to the minor. What is Y supplying? Mobile phone. Is mobile necessity, guys? Give me the answer.
No, sir.
Mobile is not a necessity. See, now you might tell today, Corona, internet technology, mobile is necessity. No, necessity, the law says necessity to live your life. What is to live your life? You need a shelter, house, food and water, clothing. This is only necessity, not mobile phone. Therefore, Y cannot recover any money. Next, Z lend 50,000 for purchase of necessities. Therefore, Z also can recover. So only X and Z can recover. Y cannot recover.
Sorry.
So somebody is asking question. Kushi is asking, is minor having children? See, it is the question. Let's not get into practical challenges of the question. Question is given. In exam, you just have to write what is there, what is the answer. See, in exam, they will sometimes drop the questions in such a way that you will get deviated. So you should not give importance to all of that. Yeah, so question number 5 is again fairly simple, straightforward question, guys. Explain the meaning of contingent contract. State the rules relating to each contract. This might come for a 6-mark question. Meaning definition, very simple definition. I explained in the video also, YouTube video. Write the definition. State the rules. Write down all the rules from textbook. Copy, paste in your own words. Clear, guys? At least the side headings you have to write from textbook. Next, Darshita, can you read question number 6?
So I have a doubt in fifth question. Are the rules happening of the event, non-happening of the event? Are these?
Yeah. That it's that only. Yes.
Okay, sir. So
Happening,
shall
not.
I read the next question?
Yeah, question 6.
A
Any doubt?
agree.
Sorry, any doubt till here, guys? Anybody else? Just give a minute, Darshita. I'll just see if anybody's typing. Any doubts till here, guys, in this chapter before we proceed to next question? No doubts. Okay. So I think Gaurav has a doubt. Just give me a minute. I'll just unmute him also. We'll just discuss that, and then we'll. Yes, Gaurav.
So for rules relating to enforcement of contingent contract,
Okay.
is it the 6 points which are given in the reader or the 4 points which are the essentials of the contract?
See, take page. If you see, take page number. I don't know which page, but if you see, there'll be a heading called rules relating to enforcement. There'll be 6 points over there.
Yes, sir, that one. Okay.
Very clear.
Okay, sir.
If you see the other 4 points which they're given, they have just given those points to explain the definition for you. So it's the points: event happening, event not happening, then within specified fixed time, not within specified fixed time, contingent on impossible event. These are the points you have to write. Side headings. Okay. And I have explained these points in the video also. You can go through them. Any doubts in those points, you can absolutely ask me here. Feel free, I'll explain. Next. Darshita, go over to the 6th question.
Yes, sir. A agrees to pay B rupees 50,000 if B marries C within 1 year. State the legal position in each of the following alternative cases. A. If B marries C after 1 year. B. If B marries C within 1 year. C. If B marries D within 6 months of agreement. D. If B marries D within 6 months of agreement. Subsequently, D dies and B marries C within 6 months of marriage D.
So take a minute time, guys. We'll go through and we'll discuss in 30 seconds. Just write the 4 answers in your notebook, or you just go through that.
To pay B rupees 50,000 marry C within 1 year. State the legal position in each of the following alternative cases. B marry C after 1 year. Not valid. B marry C within 1 year. Valid. B marry D within 6 months of agreement. Not valid. Valid.
Can we start discussing, guys? See, guys, I'm getting the answers. First one. See, this is first one. This is a contingent contract. Just a second, guys. Just 1 second. Yeah, go ahead. No.
If B marries C after 1 year, it's valid.
No. Read the
It's not
contingent
valid.
contract.
It's not
A
valid.
agrees to pay B 50,000 if B marries C within 1 year. He is marrying after 1 year, therefore no. This again, guys, in exam, I know this very well. 8 out of 10 students lose marks in a question, not because they don't know the concept. All of you know the concepts. There are only two things. You will not know which question, which is the answer. You have to be very clear in that. Like how Gaurav asked out, these 4 points, those 6 points. You have to be very clear in that. In class, I'll make you write all that, but now we don't have time for that. And second, you have to read the question 2 times. The first 15 minutes when they give you for exam, please don't do anything except for reading the question, understanding the answers. Again, when you come to the question, read it properly. Reading, now follow, guys, it's a very competitive exam. Lakhs of students writing across India. More than 3 lakh students might write across India. Now the main objective is, person who's setting the paper is somebody who's 60 years. Follow, guys. All your age will be in the age group between 15 to 18, if I'm not wrong. Now, people setting the paper is having 4 times your experience. They will know how to play with your thing. They know what you'll do. They might give you the question intentionally, half question in this page, half question in the next page. Psychologically, they'll play with you. The first question of the exam paper, question 1 and last question might be difficult. Middle might be easy. They will try to put your confidence down in the exam. Actually, the exam is easy, guys. CA exam is actually easy. It's about how you deal with those 3 R's. So reading is very important. I'll again specifically talk about this a little later again. So now let's come back to the question. If B marries C within 1 year, answer is no. That is the second question.
If B marries C within 1 year, this is valid.
Valid, yes. So Kriti, others also valid. Kriti and all of them. Yeah, Kushi, correct answer. Next, third one.
If B marries D within 6 months of agreement, yeah, this is also, no, this within 6 months, yeah, this is, no, not valid. This is D, so not valid.
Okay, others? Follow, guys. The minute you might see within 6 months of agreement, oh, perfect, within 1 year, therefore it is valid, you might write valid. But if you see here, B marries C within 1 year, but the question is B married D. D is somebody else. You have to be careful over here, therefore it is not valid. Next, fourth one.
If B marries D within 6 months of agreement, subsequently D dies and B marries C within 6 months of marriage with D. So this is valid.
So if you see here, the contingent contract says within the next 1 year, B has to marry C. Does not matter how it happens. So first year B is marrying D. Then afterwards D dies. So again B marries C. Therefore what is happening within 1 year? B is essentially marrying C. Therefore fourth one is valid. So 1 and 4 are valid. B and C are not valid.
Yes, sir.
Sorry, 1 is not valid.
B and C are not valid.
Correct.
B and D are valid.
Correct. B and D are valid. A and C are not valid. Yes. Anu, yes, you have a doubt. Just 1 second. Let me unmute her before we go to the next question. Yes, Anu, you can unmute and ask your doubt.
Yes, sir. I have doubt in the D.
Okay.
The minute B marries D, won't that contract be rescinded?
No. See, contract won't come to an end. The minute B marries D within 6 months, they will say, okay, contract is not valid. But see, the essential of contingent contract is the event should happen within 1 year. Now, within the first 6 months, event did not happen. Sure. If they wait for another 6 months, C is marrying D. So you have to see overall picture. Throughout the entire period of contract, is the event happening or not?
So, sir, will this applicable for C also?
Applicable for C in the sense?
He married within 6 months. So the minute he married, the contract be rescinded.
Contract, you see, contract is between A and B, not C. So C is a third party. C is not part of this contract itself. Contract is between A and B. So they will decide who will pay, who will not pay.
Oh, okay, sir. Thank you.
Okay. Next.
So shall I go ahead?
Yeah. Last two questions. Next chapter I'll give it to somebody else. Yeah, go ahead, Darshan.
No problem. Mr. Chetan Jain had found a mobile on the road. It belonged to Mr. Sham. Sham asked Chetan to return it and Chetan denied. Advice. Sir, Chetan should return it to Shyam because it is liability of a person. I guess it is quasi contract section 71.
Correct. Quasi contract, the provision says responsibility of finder of lost goods. Section 71 says
No, sir, it is section 72.
no,
I just saw it.
no, it's response. See, it is 71 only. Chetan
Okay,
had
rights
found a
of the
mobile.
finder of goods.
It is
Yeah.
71 only. Section 71. Chetan Jain found a mobile on the road. It belonged to Mr. Sham. Sham asked Chetan to return it and Chetan denied. So responsibility of finder of lost goods. Finder of goods, he has to return it. Go to the last question, Darsh.
Mr. Suraj received rupees 1 crore in his bank account because of a technical error at bank. He withdrew the money. When the bank asked him to return it, he denied. Advice. So this is the true or false question.
Yeah, true or false question. Answer is you have to return it. I'll add one more question now. I'll just draw it here for you guys. Now let's say, I think I explained this video in the video, but still let me ask for this. Let's say Swiggy is coming to your house. Now everything is online. He's coming and giving you some food. He's saying online payment has already happened. Now you are saying no, I never ordered the food, but the food has still come to you. You are saying no, I didn't order it. The Swiggy is saying I don't know what to do with the food. It's already paid. Do you want it or not? So you're saying okay, fine, it's coming for free. So you take it and you ate the food. After half an hour, Swiggy is again coming to you and he's saying, sir, sorry, by mistake I delivered to your house. It's supposed to go to your first floor house. Address was wrong. Can you please give the food back? What should you do? You should either give the food back or you have to give the money. Now you are saying, no, I didn't ask for it. So you gave it to me for free. Now who's right here? Swiggy is right or person is right?
Swiggy.
Swiggy is right because if you see the concept, obligation of a person enjoying benefits of a non-gratuitous act. Swiggy's intention is not to give the food to you for free. Their intention was to deliver the food to somebody who has paid. He delivered it lawfully and he did not intend to do it freely, but you took it and you ate. So you have to return the food. If you already ate the food, then you have to return the money back to Swiggy. If you didn't want the food itself in the first place, you should have not even collected the delivery itself. This is about non-gratuitous act. Concept is again in section 70. Section 70 talks about this example I gave. So we are done with this. Let's move to the next unit 5. I'll open the unit 5 handle.
So shall I unmute myself?
Yeah, sure.
Mute myself, sorry. Yeah.
So we are now in unit 5. I hope you can see my screen. I'm presenting unit 5 questions. Take 2 minutes time, guys. Again, take 2 minutes time. Please go through the unit 5. Sorry, go to the first 10 questions. We'll discuss in a minute. In 2 minutes, sorry. Go ahead, guys. Can we start or do you need another minute, guys, for discussing the questions? And also, if anybody is interested to read the questions, just type you want to read. I'll unmute you. Again, guys, if screen is difficult for you, you can have the questions separately and just listen to the audio. Anybody who wants to read. Otherwise, I'll pick somebody on my choice. So I'll just give a minute. Yeah, Riddhi, I'm unmuting you.
Yes, sir.
Yeah, Riddhi, you can start reading the questions. We'll discuss them one by one.
Anticipatory breach of a contract takes place at the time when the performance is due.
Answer.
True.
Now follow very carefully, guys. Anticipatory breach of contract takes place at the time when performance is due. Now anticipatory breach can take place either at the time when performance is due or before the performance is due itself. Therefore, first answer is false. Riddhi, can you read second question?
Aggrieved party is entitled to claim the highest of the amount of penalty or actual compensation. True.
Answer, guys. Second one, I'm just waiting for other answers. First one is false. Second one, no, they're saying aggrieved party can claim if either the penalty or the actual compensation. So if penalty is 10 lakhs and actually he suffered loss of only 20,000, can he claim 10 lakhs or 20,000? He can only claim actual loss suffered. Therefore, second answer is also false.
Please, can you explain it again?
Yeah, so I'll explain the concept of penalty and liquidated damages. It's a little important also. Just a minute. So follow very carefully, guys. I'll just present the whiteboard for this. See, now there are two concepts called penalty and liquidated damages. One is penalty versus liquidated damages. Both are called prefixed damages. Now, if you see in the, I'll explain both English law and Indian law, but for exam, you have to read only what is Indian law. In English law, they clearly differentiate what is penalty, what is liquidated damages in the contract itself. Therefore, there is no issue. Contract will mention if something is a penalty or if something is liquidated damages. Therefore, no issue in English law. But are we studying English law? No, we are studying Indian law. So what is Indian law saying? Why are they giving about English law suddenly in the book, guys? Who drafted the Indian Contract Act? British people drafted it. What we did, we just copy pasted and changed. The Contract Act became the Indian Contract Act. We just changed the name and we changed the few provisions. That's all. Therefore, what Indian law is saying, in Indian law, there is no differentiation between penalty or liquidated damages. They will just mention something called prefix damages. Now, to ascertain if something is a penalty or if it is a liquidated damages, it is based on case to case. The court will decide case to case based on the nature of the transaction and the amount mentioned, whether something is penalty or liquidated damages, and they will give the award. If the penalty is mentioned in the contract, just to make the person scared, just to make the person scared. Now, for example, I'll give you a simple example. In ICAA exams, if any student is caught cheating in the exams, what is the rule? He will be banned for 5 years from writing the exam. I will keep a new rule now. If somebody is caught cheating in ICA exams, he will not be able to write that attempt. He can write in the next attempt. Two rules now. Two rules I'm creating. If somebody is cheating in ICA exams, next 5 years he cannot write. Plus he has to pay 1 lakh. Okay, no need fine. Just 5 years he does not pay. Second, if he's cheating, next attempt he can write. Now in this, which is penalty, which is liquidated damages? Liquidated damages are generally reasonable. Meaning, okay, you made a mistake. For this mistake, remedy is don't write this attempt, write the next attempt. Penalty is threatening somebody. If you do this, you are going to suffer a huge loss. If you are caught cheating, next 5 years you cannot write any CA exam. That means almost your life, 5 years you can't write CA, it's almost over. So penalty is huge. So if the penalty is very huge, it is going to scare you, it is going to be very terrorism, then it will be called a penalty. Otherwise, the same thing will be called a liquidated damages. Clear, guys? Have you understood this part first? First, to differentiate between what is a penalty and what is liquidated damages. Now, the court is also saying, in case of prefixed damages, let's say I am prefixing damages to be 1 lakh in the contract. Now, whether this 1 lakh is penalty or prefix liquidated damages depends on case to case. Now, let's say actual loss. Let's say A is selling goods to B for 10,000 rupees. B has to make the pay. Sorry, A has to deliver the goods to B on 10th of Jan. So, because A is not delivering the goods to B on 10th of Jan, B is not able to sell it to C. So B is suffering a loss of how much? Let's say he is suffering a profit loss on this 10,000. He would have sold it to C for 15,000 rupees. He will suffer a loss of 5,000. The contract says if there is no delivery, there is a prefix damage of 1 lakh. Now, can B claim from A 1 lakh or 5,000? 1 lakh is the upper limit, prefixed upper limit. You cannot say just because A did not deliver on 10th, he has to pay me 1 lakh because contract has that. No. You have to pay what is the loss suffered by B because of delay. You have to pay 5,000 only. Now the concept of this 1 lakh is penalty or prefix damages depends on the facts of the case, whether it is a high amount or low amount, whether it is kept to scare you or just kept to claim the compensation lost. This is the concept of prefixed damages. I hope I'm clear in this. Let's go back to the questions. So if you see this question, the agreed party can only claim the highest amount of penalty or actual damages. No, he can claim he will only get the actual compensation. Can you read the next question, Reddy, for us?
Special damages can be claimed whether or not the special circumstances are communicated to the promisor.
Answer.
False.
Very clear. False. The word itself says special damages. You can claim only if the special conditions in the contract are communicated from the promisor to the promisee. Next one, question D.
The right to claim quantum merit arises only in the case of quasi contracts.
Answer.
So it would be false, no, because
Correct. Answer is false. For this, you should understand what is quantum merit. Quantum merit means claiming what belongs to you. Now, for example, I'll give you best example. Let's say you go to a CA class, somewhere you're going. You have paid 10,000 rupees for the subject. Let's say you have paid 10,000 rupees. I'm giving you CA example because it'll be easy for you. You have paid 10,000 rupees for the faculty. Now, faculty has covered 90% of the syllabus. Now, after 90%, faculty fell sick. Faculty fell sick, so he's not able to take the batch. He's requesting students, this time I cannot take the 10% batch. I will provide you recorded lectures for this. Balance we will go later. Now, can the student claim the 10,000 rupees back to, I want full refund because service is not completed? No. Here you can say 90% of the work is done. So at least pay 90%, 9,000 rupees. If you want, we will refund you 1,000. So the concept of quantum merit says, if you have performed a work, and if you have completed some percentage of the work, then at least for that percentage of the work, you have to receive the payment. So quantum merit applies for all contracts. Any contract, the concept of quantum merit is applicable, not only for quasi contract, even for quasi contract also. Therefore, answer is false. Next question. Sheldon, no, answer is not true. Answer is false. Question number 5.
Penalty is not enforceable in India.
Answer.
True.
See,
No, false.
see, there is no concept of penalty in the contract act, but you can mention it in your contract and it can be enforceable. Therefore, it is false. Penalty can be enforceable. Next question.
Specific performance can be granted in case of contract to marry.
You have to see the sound behind you, Riddhi. You have to just see that. Specific performance can be granted in case of contract to marry. Answer, guys. I'll give you the example, then you tell me answer is whether it's true or false, because everybody are giving true and some are giving false. Let's see. A and B agreed to marry. Let's say the functions, initial functions like the engagement and all of that got over, reception and all of them got over. There was the day of marriage. The day of marriage, A and B had a huge fight. So B decided that he will not marry. He is walking out of the wedding. Now what A is doing, going and filing a case in the court, saying, because of this, I suffered huge loss. Now I want to marry B only. Make B marry me. Give me a decision, specific performance. Ask B to marry A. Can court give this kind of decision, guys? Is it possible? B leaving the marriage in the middle is not right. A is suffering loss. For that loss, court can claim ask B to give compensation to A. Any compensation, 10 lakhs, 20 lakhs, amount spent by them, that can be given. But can they ask B to marry A? Specifically asking you to perform. I'll give you one more example. Second example, let's say Salman Khan and Karan Johar entered into an agreement to direct a movie. Now, after 50% got completed, and after Karan Johar paid the entire money to Salman Khan is now saying he will not act in the movie for various reasons. Now, Karan Johar is filing a case against Salman Khan saying you have to act in the movie. Court is giving order. Here, if Karan Johar gets his money back, is it going to be helpful? No, because already 50% of shooting is over. He can ask for specific performance. Remedy should be specifically ask Salman Khan to act for the remaining movie also. Here it is allowed. But in marriage, can I ask somebody to specifically marry somebody by giving a court order? Absolutely not. Yes, suit for injunction is also fine. You can get an injunction order asking Salman Khan not to act in any other movie until you complete acting in this movie. That is also fine. You can claim any remedy you want. But in this marriage case, you cannot claim specific performance. You can only claim for damages. Therefore, answer to 6 is F is false. Can you read G?
Yes, sir. Penalty is a fair and genuine pre-estimate of damages likely to result due to breach.
Answer, guys. We just discussed so much about penalty. I want everyone to get the correct answer. Riddhi, what is the answer?
So I'm not getting it still.
See, what the wordings are saying here is penalty is a fair and genuine pre-estimate of the damages likely to result in breach. See, genuine
Is it
estimate.
true, sir?
Genuine estimate is called liquidated damages. I just explained penalty is a very high amount and unreasonable amount. Penalty is an unreasonable amount. Therefore, answer is false. Penalty is not a fair and not a genuine pre-estimate. So answer is false. Everybody else got it correct. Good. It's okay, Riddhi. Making mistakes in class is fine. Exam, you should not make this mistake. Next question.
Liquidated damages need not be specific at the time of formation of contract.
Answer, guys, for question number H. So liquidated damages is one of the type of prefixed damages. Look at the word. The word itself says prefixed. Therefore, you have to mention at the time of formation of contract itself. Later, you cannot come and ask. Therefore, answer to H is also false. Can you read I?
Remedy can be claimed even if there is no breach of contract. False.
False. Very simple. Only if you breach a contract, you can claim remedy. If somebody is performing a contract, how can I claim remedy? Therefore, answer is false. Last question.
Suit for injunction relates to asking the other party in the contract to complete his performance in the contract. True.
Answer, guys. No, guys. See, suit for injunction, and if you see the remedies, there are two types of remedies. One is injunction, one is suit for specific performance. Now, injunction is nothing but stay order. asking somebody to stop doing what they're doing. Now let's say Salman Khan stopped acting in Karan Johar's movie. He's acting in some other movie now. Then you will claim for injunction to stop him from acting there. Now you want to do him to act in your movie. That is called suit for specific performance, asking him to perform what he has already promised. So if you look at the statement here, suit for injunction relates to asking the other party in the contract to complete his performance of the contract. No, to complete his performance is suit for specific performance. Injunction is to ask the person to stop performing what they are performing. It is like a stay order. Therefore, answer for J is also false. Injunction is not to do something, stopping him from doing something. Or if he is doing something which he should not do, then you should again ask him to stop. This is answer for all the 10 true or false. So I'll give you simple. All the 10 true or false for this unit is false. Question number A to J, everything is false. Anybody got 10 on 10? Anyone? I can see hands. So you can raise your hand or you can type saying if you got 10 on 10. No, 8 also it's not good. I want 10 on 10. Good. Anything above 8, 8, 9, 10 is also good. But if you're getting less than 8 in these 10 true or false, you need to work on your concepts in breach of contract and remedies. 7 and less than 7, you need to work on, guys. Come on. You revise better. Next. Let us proceed to next question. Really, do you want to read or should I give it to somebody else? Actually, it's okay. You read. So anybody else who wants to read? Soumya, can you read? I'm unmuting you, Soumya. Can you read the question?
Hello, sir.
Yeah, go ahead, Soumya.
Explain the meaning of contingent contracts and state the rules relating to such contract.
Sorry, this is there in this. I forgot to take it out. This is from the previous chapter. Just leave it. Leave question number 2. Go to question number 3.
Okay, sir. X entered into a contract with Y to supply him 1,000 water bottles at 5 rupees per water bottle to be delivered at a specified time. Thereafter, X contract with Z for the purchase of 1,000 water bottles at 4.5 per water bottle. Under the same time, told Z that he did so for the purpose of performing his contract entered into with Y. Izzat failed to perform his contract in due course and market price of each water bottle on the day was 5.25 per water bottle. Consequently, X couldn't procure any water bottle and Y resigned the contract. Calculate the amount of damage which X could claim from Izzat in this circumstance. What would be your answer if Izzat had not informed about the Y's contract? Explain with reference to the provisions of the Indian Contract Act 1872.
Okay. So take a minute time, guys. Big question. Take a minute time. It's a past exam question also. You can see the wordings itself. So take a minute time. Go through the question. We'll discuss in a bit. Okay, so let me explain, guys. I'll present the screen for you. Just a second. Now you see the question. They're saying X entered into a contract with Y. So let me explain this question. X has entered into a contract with Y to supply him 1,000 bottles at 5 rupees per bottle. So X will supply to Y 1000 bottles at rupees 5 per bottle. Thereafter, X contracts with Z for the purchase of 1000 water bottles at rupees 4.5 per bottle. So X is going to sell to Y 5 per bottle. Therefore, he is buying it from Z, same 1000 bottles at rupees 4.50 per bottle. Now, and at the same time told Z that he is informing Z. See here, X is clearly informing Z that he is purchasing these bottles for the purpose of entering into the contract with Y. Because he entered into contract with Y, he is informing this to Z. Now, Z failed to perform the contract in due course and the market price of each of the water bottle on that day was 5.25. Now, actual market price on the day of the contract is 5.25 and on the due date, Z failed to perform. Consequently, X could not procure the water bottle and Y rescinded the contract. Y cancelled the contract. Rescinded means cancel the contract because he is not able to sell the goods. What would, now they're asking calculate the amount of damages which X can claim from Z. How much can X claim from Z? So most of you gave the correct answer. If you see very carefully over here, in the first order,
750, sir.
sorry?
750.
No, not 750. Now, in the first case, X has informed X. In the first case, X has informed Z about this incident. Therefore, what is the loss X is getting? If you see the loss X is getting, there is special circumstances here. What is the special circumstance? He's mentioning about that and he's also not got the good. Therefore, X is entitled to claim how much, what is the loss for X over here? If he had supplied at 4.5, he would have sold at 5, 1000 bottles into 5 minus 4.50. He would have made a profit of rupees 500. This profit is lost because the contract is cancelled. Therefore, he will be entitled to claim rupees 500 from Y. Next, second part of the question. What would be your answer if Z had not informed about the Y's contract, explain the provisions to the in the contract? Now, if X had not informed Z about the contract, then if you see what is the market price of water bottle was 5.25. Can I get answer for second case? Guys, if it's not informed, what will be the answer? Can you guys just type it out? Now, if you had, let me explain, guys. If X had not informed Z about this, now Z can claim. Now, let me explain. Z will say, see, I did not know that you are going to sell this to Y. You are not going to sell this to Y, so I don't know about all of these things. I cannot pay you 500 rupees profit you have lost. Z's claim is very much valid. Now, what will happen? What X will tell? X will say, see, I should have bought from you for 4.50. But today, what is the market price? 5.25. If I am going to buy in the market, I have to pay extra how much? 75 paisa for every good. Into what is how many goods I'm buying? 1000 water bottles. So 75 paisa into 1000 will be rupees 750 rupees. So because you have failed to perform your contract, breach of contract, what is my general damages? No need special damages. General damages. I have to buy this in the market price today for 5.25, which is 0.75 extra I have to pay. 5.25 minus 4.5 into 1000 bottles, 750 rupees. So case 1 answer will be 500. Case 2 answer will be 750. Case 1, he will claim special damages of 500 because special circumstances intimated to the other party. Case 2, I will claim general damages, generally what I am going to lose. Understood, guys? Any doubts? Okay, I'll repeat the first point. Some of them have doubts in the first point. Let me repeat it again. Then I'll take up the doubts. See guys, X, Y, and Z. Now X wants to sell the water bottles to Y at rupees 5 rupees, which is fixed, and for this he is buying from Z at rupees 4.5. Now what is the profit X is going to make on the transaction? Rupees 500, which is nothing but 1000 bottles into 5 minus 4.5. This 500 that the profit is going to make, X has clearly intimated to Z, and Z has failed to perform. Therefore, X can claim from Z only the amount of profit he is going to lose from this contract. This is first part. Now, one more person is asking a doubt, another student is asking a doubt. What if X is suing for specific performance? Can he sue for specific performance? Absolutely yes. He can sue for specific performance and make Z deliver those 1000 water bottles. However, in this question they are saying he has failed to deliver. So what is the amount of damages? X can absolutely sue for specific performance also. Any other doubt guys before I proceed? Any other doubt guys before I proceed? You can just type yes, no. Can I proceed? Have you understood the question? It's very important guys. This question is important. If you have not understood, please. One second, Darshita, I'll just unmute you. Before that. Yes, Darshita, go ahead.
Oh, yes, the doubt which I have is if X is claiming in first case rupees 500, so wouldn't it be rupees 1250? So this is just the special, this is just the loss which he is losing if he cannot sell the goods to Y. So what about the actual 750 rupees which he is also not getting?
Which 750 is that?
So 4.50 minus 5.25.
No. See, in the first case, how much is he actually losing in the contract? He's losing 500 rupees. That's his profit, right?
Yes, sir.
See, X is buying from Z only for the purpose to sell to Y, correct? Not to somebody else. So I understand what you're saying. Your concept is, what if he sells it for 5.25, purchase it for 4.5? You're saying this 750, correct?
Yes, sir.
Yeah. So now here what is happening is he's purchasing from Z only to sell to Y, and he has clearly informed Z that I'm purchasing from you only to sell to Y for 5. Now what is the loss for X? Y cancel the contract. Therefore, he is not able to sell it to him for 5 and make the profit of 500. His opportunity cost is 500. Now let's say you're in a job which is paying you 8 lakhs. You have a job which is currently paying you 8 lakhs, but you don't like the job. You're getting a new job offer from some other company which is for only 7.5 lakhs, but you like the job very much. It's your dream job. Will you take it up or not? You will take it up absolutely, but what is your loss? Opportunity loss, only 50,000.
50,000.
Now, if you had stayed in this job, you would have got a promotion next year and your salary would have increased to 9 lakhs. Can I say my opportunity loss is not 50,000? It is 1 lakh plus 50,000, 1.5 lakhs. Can I argue like that? No, because the new job also you might get promotion if you work for a year, correct? So here you cannot say if X had sold to somebody else for 5.25, he would have got 750. No, he entered into contract with Y for 5.25, sorry, for 5, therefore loss is only 500.
Sir,
Now,
actually, I got 1250 by cancelling 5.25 minus 5 rupees, which is 1.25 into 1000 bottles.
sorry, 5.25 minus
5 rupees. So you get
0.25.
Oh, sorry, it's my calculation mistake.
Okay. I think that's sorted. See, here opportunity cost we will not mention. The question is, what is X losing in the first case? Because Z is not supplying, X is only going to lose 500 because Y cancelled. So 500. In the second
case.
Yeah, in the second case, what happens? Now, Y has cancelled the contract, but X has not specified to Z. X is clearly not specifying to Z that whom he is going to sell these water bottles and what price he is going to sell. X has not specified anything. Now, what is happening? Z is not supplying to X. Therefore, X has to buy this water bottle again from the market. What is the current market price? 5 rupees 25 paisa. So if he wants to buy 1000 bottles at 5 rupees 25 paisa, how much extra he has to spend? If you see how much extra he has to spend,
0.75.
0.75, because earlier he would have only paid 4.50. 0.75 is nothing but 5.25 minus 4.5, which is 0.75. He has to pay extra 0.75 for every 1000 bottle, which is 750. So extra cost for him because of Z's breach of contract is 750. He will buy in the market for 5.25 and claim from Z how much loss he got, 750 rupees he will claim. Understood, guys?
Yes, so understood. Thank you so much.
Anybody else in the chart? I'll just check 1 second. Just give me a minute. I'll just read the chart. So he cannot sue for general damages. Kushi, yes, he can sue for general damages. That is what is the question. Second part 750 is the general damages. Yes. So in the first part, amount recoverable is 500. Second part, amount recoverable is 750. Correct. Kushi, can he sue for general damages in the first point? No. What is the general damage in the first point? There is no general damages because he is getting this and the special condition is clearly mentioned. Therefore, no. Next. Ilavers is asking, what if the market value is 4? How much can he claim? Okay. What if the market value is 4? Just a second. See, if the market value is 4 rupees, follow guys, it is 4.5. So it has decreased to 4. Now, good question, Ilavers. See, now if the market value has decreased to 4, guys, let me explain. In the first case, he cannot claim. In the first case, he can still claim. Because you have not supplied on time, and I was also not able to buy in the market. Even though market price is 4, I was not able to buy. Question is saying X was unable to buy in the market and the contract got cancelled. Still you are losing 500 rupees, correct? 500 rupees is your loss. Therefore, you can still claim 500 rupees profit in the first case. In second case, market price is 4, contracted price is 4.5. Is there any loss suffered by X here? Any loss suffered? No, loss is not suffered. So what damages he can claim is nominal damages. Remember the concept nominal damages. See, he has breached. I agree that the person has made a mistake. Z has breached the contract. But did X suffer any loss? No. X did not suffer any loss because he can buy in the market itself. Therefore, he can claim nominal damages. What is nominal damages? Z will accept he has made a mistake. Nominal damage amount will be rupees 1, rupees 10. It is more like to make you accept you have made a mistake. For example, recently in Supreme Court, one of the judges had a case against him. Court has awarded a penalty of rupees 1. He gave a 1 rupee coin also. So that is called nominal damages, where neither of the parties suffered a loss, but you have still breached the contract. So for the purpose of breaching and just because you sued the other person, court will award a nominal damages. Understood, guys? Can I proceed to next question? Any doubts still here? Riddhi, are you still on the call? Sorry, who was reading the question? Not Riddhi, actually. It was someone else reading the question. Yeah. Soumya, read the next question for us, no?
Hello, sir.
Yeah, go ahead, Soumya. Question number 4.
I can't see questions, sir.
Oh, sorry, I'll just present it again. Just a second. Yeah, question number 4, guys. Everybody also try reading. Riddhi will read it for us.
M Limited contract with Shanti Traders to make and deliver certain machineries to them by 30 June 2017 for 11.5 lakhs. Due to labor strike, M Limited could not manufacture and deliver the machinery to Shanti Traders. Later, Shanti Traders procured the machinery from another manufacturer for 12.75 lakhs. Due to this, Shanti Traders was also prevented from performing a contract which it had made with Zen Trader at the time of their contract with M Limited, and were compelled to pay compensation for breach of contract. Advice on Shanti Traders the amount of compensation which it can claim from M Limited, referring to the legal provisions of Indian Contract Act 1872.
Yeah, so good. Thank you, Soumya. So I'll just go through the question, simple question, similar to the previous one. Type your answer. What is the actual amount of compensation they can claim? Yeah, so all of you got the answer. 1,25,000, Soumya 1,25,000, Darshita 1,25,000, Kriti 1,25,000, Harshal also 1,25,000. Everybody is perfect, correct. Correct answer. You will be able to claim 1,25,000. Fairly simple question, similar to the previous one. Here, if you see, M had a contract with Shanti Traders to make and deliver certain machinery to them by 30th June for 11,50,000. Due to labor strike, M could not manufacture and deliver the machinery to Shanti Traders. Shanti Traders procured the machinery from other manufacturer for 12.75 lakhs. So extra how much they paid? 1,25,000. Due to this, Shanti Traders was also prevented from performing the contract which they had made from Zenith Traders at the time of entering the contract, and M Limited were compelled to pay compensation for breach of the contract. Advise Shanti Traders the amount they have to pay. Amount is 1,25,000. This will not come under supervening impossibility. You cannot say due to labor strike now. Labor strike now. See, understand guys, the concept of supervening impossibility when it will come is impossible to perform. Now, impossible to perform and not in your control. Now, M Limited could not manufacture because of labor strike. Now, let's say there were floods or there was an earthquake or because of coronavirus there was a lockdown. Now, if there's a lockdown, it is not in M Limited's control to do the performance of the contract. Hence, there is supervening impossibility. Here, labor strike is within the control of M. Employees, laborers of M are striking, doing the strike. Therefore, they can control and avoid the strike and they can perform. They cannot give this as an excuse. Therefore, this will not be supervening impossibility. Yes, see, if you remember the case law name in exam, guys, you can write the case law name also. See, I'll tell you the difference, okay? In the CA, if a similar question comes in CA final for tax, they will give you the same question. There will also be one line. Please write case law. They will ask, please write case law. Here it is not required. So if you remember the case law, you can write. Now, what is the concept for this question? The concept is normal general damages. Because of you, I have lost 1.25 lakhs by paying extra. So you will have to claim general damages. That's all. Next. Soumya can read question number 5.
Sure, sir. X contract to sell and deliver 500 bales of cotton to Y on a fixed day. X knows nothing of Y's mode of conducting business. X breaks his promise and Y, having no cotton, is obliged to close his mill. Is X responsible to Y?
Answer.
No, sir.
So let me explain the question, guys. Here, if you see, X contracts to sell and deliver. X is going to contract to sell and deliver 500 bales of cotton to Y on a fixed day. So I'm getting answers from Kriti, wrong answer. Kushi, wrong answer. Priti, correct answer. Okay. To sell 500 bales of cotton to Y on a fixed day, X knows nothing of Y's mode of conducting business. So X does not know how will Y conduct the business and all of that. X breaks his promise. Basically, how Y is doing his business, all that X doesn't know. He's just promising to deliver 500 bales of cotton to Y. X breaks his promise. He is not delivering. And Y, having no cotton, is obliged to close his mill. Is X responsible to Y? So what is happening? Because Y did not get the 500 bales of cotton, Y's mill did not have enough raw materials, and hence he had to close down his mill. Now X wants to claim compensation. Sorry, Y wants to claim compensation to X. Here, because X failed to deliver the goods, it is indirectly leading to loss to Y, and therefore Y can claim general damages. The amount of loss he is going to make because of this 500 goods which are not supplied, breach of contract by X, he can claim the general damages. Very simple question.
So what is the amount of general damage, sir?
No. See, in this question, they have not given the facts. If they give you numbers, this is the amount, this is the loss, then you can put the amount. Otherwise, in exam, you can just write, he can claim for general damages. Yes, he can sue. Court will see what is the most reasonable amount and give the amount. That's all.
Okay, sir.
Okay. Can you read the next question for us, Soumya?
Yes, sir. Mr. X and Mr. Y enter into a contract on 1st August 2018 by which Mr. X had to supply 50 tons of sugar to Mr. Y at a certain price strictly within a period of 10 days of a contract. Mr. Y also paid an amount of rupees 50,000 towards advance as per the terms of the above contract. The mode of transportations available between their place is roadway only. Severe flood came on 2nd August 2018 and the only road connection their place was damaged and could not be repaired within 15 days. Mr. X offered to supply sugar on 20th August 2018, for which Mr. Y didn't agree. On 1st September 2018, X claimed compensation of rupees 10,000 from Mr. Y for refusing to accept the supply of sugar, which was not there within the preview of the contract. On the other hand, Mr. Y claimed for refund of rupees 50,000 which he had paid as advance in the terms of contract. Analyze the above situation in terms of the provisions of Indian Contract Act 1872 and decide on Y's contention.
So take a minute time, guys. Go through the question.
Sir, is it supervening impossibility?
Yes. So very simple question, guys. Here they are saying, read the entire question. They're saying X and Y entered into a contract on 1st August by which X had to supply 50 tons of sugar to Y at certain price strictly within a period of 10 days. Y also paid amount of rupees 50,000 because of the advance. The mode of transportation between the two places only roadway. Severe flood came on 2nd August and road was damaged. It could not be repaired and hence X could not supply it. He's saying instead of 1st August, he will supply it on 20th August, for which Y did not agree. On 1st September, X claimed a compensation of 10,000 from Y for refusing to accept the supply of sugar, which was not there in the purview of the contract. On the other hand, Mr. Y claimed refund of 50,000, which he had paid as advance in the contract. So what will happen here? Supervening impossibility, contract will become a void contract. Whatever benefit is obtained from the contract has to be returned. The 50,000 which was paid as advance will be returned. It is not fault of both the parties. He cannot claim for 10,000 also. Understood, guys? Correct. Everybody got the correct answer. For delivery of goods where time is essential and it was not able to be performed because of supervening impossibility, contract will become void. Whatever benefit is given, 50,000 has to be returned. X cannot claim 10,000 also. Simple question. Okay. Am I audible, guys?
Yes, sir.
Okay. Now, how to present an exam, guys? You again, like I said, you need to write first. You have to write the facts. This big para, obviously, you cannot copy paste an answer. Summarize this into 3 to 4 lines and explain the facts over here. Then you write the provision. What provision you will write? You will write the provision of supervening impossibility, and you will also write time is essence of contract. If contract cannot be performed on the time when the time is mentioned, it will be void because other party has not given you extra time to perform. Then you write analysis based on these provisions and the facts. We can analyze the following. Then conclusion you will write. Conclusion will be supervening impossibility. Contract is void. 50,000 should be refunded. This if you write explain detailed into minimum 1 page. I think this should easily go to 2 sides. You will get your 6 marks. Next.
Shall we move to next question, sir?
Yes. So you can, what you
Mr.
can do, read question number 7, 8 and 9. I'll give you all 2 minutes time. Then we'll discuss all the 3 questions together. Go ahead. Yes.
Mr. A is a singer. Singer contracts with Mr. B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months, and engages to pay her 1,000 for each night's performance. On the 6th day, A willfully absents herself from the theatre, and B, in consequence, resigns the contract. Advice.
So answer, guys. Type your answer, guys. You finished all the 3 questions. Just take a minute. Go through 7, 8, 9. Then we'll discuss them. Okay, so let me discuss the questions. M is a singer who contracts B, the manager of theatre, to sing at a theatre for 2 nights every week during the next 2 months. Engages to pay her ₹100 for each night's performance. On the 6th night, A, who is supposed to sing, willfully defaults her absence herself from the theatre and in consequence rescinds the contract. Advice. No. This question has 2 parts, guys. First, let us see in viewpoint of singer what she will get. Next, let us see in the viewpoint of manager what he can claim. Now, here, since A has performed for 5 nights, she has to get payment for 5 nights. 5 nights into 100. Each night she is singing. She has to get ₹500 quantum merit. For the performance done, you have to make payment to me. This is in viewpoint of A. If you see in viewpoint of B, he would have suffered some loss. Why? Because A is not singing. Now he has to look for a new singer. Question is not clear whether B has found a new singer, how much extra money is spending, what is the amount of loss. If at all B is suffering any gender loss, let us say on the 6th night B found a new singer called C who is singing the same songs for same price, ₹100. Is B suffering any loss? Absolutely not. So B cannot claim money. But however, if B is suffering any loss, then B will have to, he can claim that money from the singer. Then it depends on the loss. If the loss is 1,000, then they'll net off and B will claim the balance 500 from A. But if the loss is only ₹200, then A can claim from B the balance 300. So it depends on facts of the case. The concept here we want to test is quantum merit. So singer will get compensation for the performance done. B, the manager, because A cancelled the contract. Absence, willfully absence, clearly leads to breach of contract. So in case of breach, if at all B is suffering any loss, that general damages he can claim. This is the answer for question number 7. Hope I'm clear with that. Next, question number 8. So
Shall I
most
read,
of,
sir?
yeah, you already read it, right? You didn't read it.
Okay, sir.
C is an owner of magazine engaged P to write articles in his magazine for a period of 12 months. However, after a few weeks, C discontinued his magazine. Advice whether P can claim compensation. Absolutely yes. Concept of quantum merit. Everybody got it correct. Very simple concept. So everybody got it correct. So Priti correct. Kushi correct. Kushi, yeah, okay. Darshita correct. Others, yes. Quantum Eleversi correct. And one more thing in the previous question, see, B can also sue. Now in this question, B can also sue A for specific performance, meaning asking A to specifically perform. Then the court can give that order. That is also possible. They're only asking us to advise. See guys, they're not saying specifically what is happening. Remember in damages chapter, remedies, any remedy is possible. Any remedy is possible. So court will decide that and you can choose what remedy you want and you can file for that suit. Here they're asking advice. So as a consultant, you can give all the possible answers. But in exam, this kind of question won't come. So don't worry. If a similar question comes, they will also write one more sentence. Advice about specific performance, advice about quantum merit. Then you can explain that point. They will ask explain viewpoint of A or explain viewpoint of B also. In question 7, a student is asking why cannot be sued for injunction. Injunction means stay order. Now, if A is doing going to a different theater, some other theater in the same time and singing for rupees 150 per night, then manager can sue A for injunction, asking her to stop singing in the different premises because you already promised to sing over here. Next, let us go to question number 9. X lends 1 lakh to Y without interest for 1 month with a stipulation that in case of default, interest shall be payable. State the legal consequence of rate of interest 2% per month, 5% per month. So all they're asking here is they're asking you to specify what are the legal consequences. Can you give me the answer? Except Darshita, I didn't get anybody else. Others, just give me your answer for question 9. Others answer, guys. Very simple. See, if it is 2% per month, now follow very carefully, guys. X lends 1 lakh to Y without interest for 1 month with a stipulation. The words with a stipulation says already mentioned in the contract that in case of default, interest shall be payable. State the legal consequences. Now, whether it is 2%, 5%, 50%, or 5,000%, who agreed for this? Why agreed for this? He already knew about this. Therefore, he has to pay whatever percentage is mentioned. However, 2% per month will become 24% annually, which is nothing but like liquidated damages. But 5%, 50 or 5,000% will be in the nature of penalty. It will still be paid because it is agreed over here. It is only that nature is one. The first case 2% will be liquidated damages. Second case will be penalty. Hope you all understood that. Next question. Soumya, can you read question number 10 for us? Last question. I don't know if Soumya has done that class. Okay, let me read. X bought a horse with a warranty that it was free from any disease. I think if she had unmuted, she can't unmute again, so it's fine.
Hello, sir.
Yeah, go ahead, Soumya. Read the 10th question.
Okay, sir. X bought a horse with a warranty that it was free from any disease. The horse was suffering from a disease at the time of sale. As a result, not only that horse dies, but infected other horse also. Discuss the legal position of X.
Give me the answer, guys.
He can claim damages, sir.
Only for that horse or for entire horses? See, obviously, see, X bought a horse with a warranty. Warranty is given that it's free from any disease. The horse was suffering from a disease at the time of sale. As a result, not only that horse died actually, but infected other horses also. Discuss the legal position of X. So, can X claim money only for that one horse which died, or for all the other horse also? All other horses. Answer
All
please.
other horses.
Very clear, all other horses, because specifically has given a warranty that it's free from any disease. Buyer is buying the horse. See, here you cannot say you can use the concept of caveat emptor, because he excess specifically asked the horse without disease and he has given a warranty also. Therefore, horse is suffering and you can claim damages for all the horses. So I think we're done with this. Before we move, any doubts? So Darshita has a doubt, I'll unmute her. Other than that, if anybody has a doubt, please type your doubt. I will ask me to unmute you. I'll unmute you. You can ask your doubt. Yes, Darshita, go ahead.
Yes, sir. The doubt which I have is X bought a horse with a warranty that it was free from any disease.
Correct.
But he was being misrepresented of the fact. So, sir, can we write misrepresentation concept in this particular
No. It is not misrepresented over here. See, they have not clearly given here from the person whom they are buying horse whether he has done it intentionally, whether it's a fraud or whether it's misrepresented. So he just told the horse is good. He's given a warranty. Okay. So later now, because of this warranty, there is a damage. So the question here is focusing more on the damages part. So you can claim money for entire thing. No need to write about misrepresentation.
So,
Not
sir, it
required.
is just the general damages, right?
Yes, general damages. Yes.
Okay.
Breach of.
Sir, how could we write it a misrepresentation? Like, what would be the cases? Then we can see that, yeah, it is a misrepresentation.
See in the question, if they give one more line which is giving you a hint, like if they mention the person, let's say he bought the horse from Y. So Y is mentioning the horse is free from any diseases. He is giving an assurance. But the horse already had a disease and Y did not know about this. Y was not aware about this. He did not do it intentionally. Then it is misrepresentation.
Sir, but misrepresentation can be done intentionally also.
If misrepresentation is done intentionally, it becomes fraud. Now, if you know, for example, if you know the horse is not well and you are still selling it by saying horse is perfect, giving a warranty, thinking X will not find out, then that becomes a fraud.
So, sir, can this be fraud now?
No, it is not fraud, because see, they have not, see, horse was suffering from a disease at the time of sale. Question is not clear here. They are not giving you, see, I'm only taking the extracts. They are not mentioning, saying whether the person who is selling the horse knows about it or does not know about it. If there's another line, if I just add one more line, Y has sold the horse knowing the horse was suffering from a disease, then it becomes a fraud. Absolutely, it becomes a fraud. You can claim damages.
Okay,
Intentional
sir.
deceiving. There should be intention to deceive. I am selling it with an intention to cheat you. I am selling a pen. I know this pen will not write. It is not working. But still I am selling it to you thinking you will not come back to me. That becomes a fraud.
Okay, sir. Thank you so much.
Okay. So with this, we are done with unit 5 and 6. What we'll do, it will be difficult to finish unit 4 before 8 p.m. So we will start with unit 4. How much ever possible we'll do it today. Next, we'll continue in the next class along with other topics. So let me open unit 4 handout. Just give me a minute. Can you see the unit 4 guys? I'm presenting the screen, unit 4. So take
Yes,
2
sir.
minutes time. Please go through the true or false questions. Guys, I'm going extremely fast. I know that. But if there's any doubt, you can stop me. Objective of the session is to discuss the questions. Concept is in the video. So Priti is asking a question. If the seller doesn't know about the fact, seller thought the horse is good and he sold it, he is still liable because he has given warranty. Now, let's say you're buying a new iPhone for 1 lakh. Apple is giving warranty of 1 year for everybody who's buying iPhone. Obviously, when they sell 1 lakh units, 1 or 2 units will obviously have defect. Does Apple know about this? No. Unintentionally there was a defect over there. So Apple will give you compensation. Same logic over here. When you buy mobile with warranty, you're getting damages recovered if there's problem. Same way with horse, whether he knows or does not know. So go through the questions. We'll discuss in 2 to 3 minutes from now. Can we start discussing, guys? So let's start, guys.
Yes, sir.
Just 1 second. Okay, so let's start. So who is going to read the questions? Let's start with the first question.
Shall I read, sir?
Yeah.
In case of joint promiser, the promise can demand the performance from any one or more of joint promises. Yes. True, sir.
Answer first one.
True.
Yeah, first one is true. So what we'll do, guys, when there are doubts over here, actually, since doubts are not for everybody, I'll discuss all the answers. Then towards the end, I'll keep the doubt. If I get similar doubts from at least more than 2 students, 2 or 3 students plus ask those doubts, then I'll take up those doubts at the moment, so that the class flow is not affected. So first one answer is true. In case of joint promises, the promisee can demand the performance of any of the joint promises. Let's say A, B, and C are giving loan to D. Sorry, D is giving loan to A, B, and C together, where they're jointly promising that they'll repay D. If A is not repaying, B can obviously ask sorry, D can obviously ask B or C. So first one is true. Can you read the second question for us, Soumya?
Okay, sir. Where one party to a reciprocal promise prevents the other from performing his promise, the contract becomes void. True, sir.
Yeah, so second answer is also true. See, where one party to a reciprocal promise prevents the other one from performing his promise, the contract becomes void. So let's say A and B have entered into a contract where A is asking B to paint his house. Now, B has come on the day of the promise to paint the house, but A is stopping him from painting, saying, no, don't enter my house. So we're one party to a reciprocal promise. What do you mean by reciprocal promise? A has asked B to paint the house. B is going to paint the house. On behalf, A will make payment to B. So reciprocal, each other is promising one work to another person. Prevents the other person from performing his promise. The contract becomes void. Yes, contract will become void. B can claim any compensation from A for his time which has been wasted.
Shall I go to next, sir?
Yes, go ahead.
Unless otherwise agreed, each of the joint promiser can't compel other joint promiser to contribute equally to the performance of a promise.
Answer.
False, sir. He can compel the other joint promises.
Okay, so where one, see, unless otherwise agreed, each of a joint promiser cannot compel the other joint promises to contribute. Absolutely not. The concept of joint promiser itself says all the joint promisers are equally and severally liable. Therefore, answer for 3 is false. Some of you are asking me doubts, but if it's only 1% doubt, just please hold on because it'll affect the class flow. End of the class, we'll discuss the doubts. Don't worry. Next. Promises. Yeah, go ahead.
Promise forming consideration for each other are called joint promises.
Answer.
False.
Answer is false. Absolutely. Promise forming consideration for each other is not called joint promises. Joint promises together jointly promise to another promisee. Next, can you read the fifth question?
Cancellation of contract is called remission. False.
Answer.
It is rescission.
Correct. Cancellation of contract is called rescission of a contract, not remission of a contract. So answer is false. Fifth one is false. Next.
The death of a promiser always discharges the contract.
Answer.
False.
They are saying death of a contract discharges means ends the contract. Answer is false. See, generally death leads to ending of the contract, but however, let's say for example, A has taken a loan of 1 lakh from B. Now, after taking the loan, he told he'll pay back within 3 months. Now, what is the performance of contract? A has to make the payment back to B. Now, after 1 month, let's say A died. Can I say contract is discharged, contract is ended? No. A's legal heirs, let's say C, has to make the payment to B. Now, here you cannot be like, no, one party has died, so therefore contract is ended. Absolutely not. You have to wait until you can ask the other person to perform. But if this involves contract of skill, where personal skill is involved, then death leads to end of the contract. Let's say a contract is for painting, then only the person who has to paint can do the performance. Next, can you read the next question for us?
Yes. Discharge on contract by anticipatory breach of contract takes place when the performance is due. False.
Correct answer is false.
Anticipatory breach takes place before the performance is due.
So anticipatory breach can take place either at the time when performance is due or even before. Before itself you're estimating. I'll give you an example for this. Let's say A asked B to sell his painting to A. They have agreed for 1 lakh. He told he will sell it on 10th of Jan. But on 5th of Jan itself, B is selling the painting to C for 1,50,000. So A can anticipate by seeing this transaction, he can anticipate that on 10th of Jan, B will not perform to A. Therefore, discharge of a contract, ending of a contract by anticipatory breach takes place when performance is due. No, it can take place when performance is due. I can expect today he will not come itself or much before itself. Therefore, answer for G is false. Next, H1.
The insolvency of promisor discharge the contract.
Answer.
True.
Correct. Insolvency of promisor discharge the contract. True. Insolvency. Once a person becomes insolvent, what happens? He becomes a person. Remember the concept, guys. Incapable. Previous unit. Incapable to enter into a contract. People who cannot enter into a contract. One of the examples over there is insolvent. So insolvent cannot enter into a contract. It will automatically discharge the contract. Answer is true. Whenever a contract becomes void or ends, guys, whatever benefit obtained by any party, he should return the benefit to the other party. Next one.
Substitution of a new contract in the place of an existing contract is called alteration. False.
It
It's
is
called
false.
novation.
The existing a contract and other contract is called novation of a contract, not alteration. Therefore, answer is false. Last one.
Where initial impossibility is unknown to both the parties, the contract will not be void.
Answer, guys.
False.
Read carefully. Where initial impossibility is unknown to both the parties, contract will not be void. They're saying. Therefore,
Contract
answer is
will be
contract will be false. Sorry, will be void. Therefore, this statement is false.
false.
Now, let's say A is asking B to swim across Pacific Ocean within 24 hours. Can he do it? No. So it is impossible. B also should know it is impossible. A also should know it's impossible. But if both are entering into a contract thinking if it's possible, initial impossibility itself, it is unknown to both the parties, then the contract will be void. It do not say it now, it will be void. So how many of you got score? Can anybody 8 on 10? Can you raise your hand? Darshita, you have a doubt? I'll unmute you in a while. Just give me a moment. We'll discuss the doubts together. You can just keep it. You can note and keep it. We will discuss the doubts, guys. Don't worry. I'll give you time in the ending. Just let's. So good. 9 on 10. Sriranj 9 on 10. Kushi 7 on 10. Soumya 10 on 10. Good. Anything 8, 9 and 10. Good. Others you have to work on the concepts. It's okay. 7, 6, 5 also is fine. But at least get to the understand the concepts. No. Next. Soumya, you can mute yourself. I'll pick somebody else to talk.
Okay, sir.
Anybody who wants to talk, or I'll choose somebody. Sri Ranjini or Sheldon or Ronak, anybody? Not somebody who has already spoken today. Somebody who has not spoken till now. Yeah, I unmuted somebody now. Sri Ranjini, I think.
Yes, sir. I'll read.
Okay, you can go to question number 2A. Doubts, I know only 2 people have asked me doubts. I'll just hold it. We'll discuss then.
Shall I
So
start,
what
sir?
we'll do, we'll go until 8 p.m. How many other questions we can complete in this unit we'll do today. Balance we'll do on the next class. 8 p.m. sharp, I'll keep the session open for doubts for the last 15 minutes. Yeah, go ahead, Sri Ranjini.
Krish, Kamya and Ketan are partners in the firm. They jointly promised to pay 6 lakh rupees to Diya. Kamya become insolvent and the private assets are sufficient to pay 1/5 of her share of debts. Krish is compelled to pay the whole amount of Diya. Examining the provisions of Indian Contract Act 1872, decide the extent to which Krish can recover the amount from Ketan.
Take a minute time. Go through the question, guys. Answer, guys. So Soumya got the correct answer. Others. So let me explain. So if you see here, Krish, Kamya and Ketan are partners in the firm. They have jointly promised to pay 6 lakhs. They've jointly promised to pay 6 lakhs to Diya. Now, Kamya becomes insolvent and her private assets are sufficient to pay 1/5 of her debts. Therefore, Kamya is not able to pay the money here first. Krish is compelled to pay the balance of the whole amount to Krish is balance of the whole amount to Diya. With the provisions, explain how much can Krish recover from Ketan. Now, Kamya can only pay 1/5 of her debts. So first let us see what is 1/5 of 6 lakhs. What is 1/5 of 6 lakhs? That comes to 60,000 into 1/5. Can someone give me the amount, guys? 6 lakhs into 1/5. Yeah, so good. 1,20,000. So Kamya will be able to pay only 1,20,000. Follow, guys. Everybody should pay equally, correct? So Ketan should pay 2 lakhs, Krish should pay 2 lakhs, Kamya should pay 2 lakhs. This is the logic. Everybody should pay 2 lakhs actually. But what is happening? Kamya is paying only 1,20,000. Let's say Ketan paid full 2 lakhs and Krish also paid full 2 lakhs. First round, Krish paid 2 lakhs, Ketan paid 2 lakhs, Kamya paid only 1,20,000. Now, the balance deficit, what is the deficit? 80,000, which is the deficit, balance deficit. Krish paid on behalf of Ketan. Krish paid on behalf of Ketan. Now, this 80,000, Krish has paid totally now 2,80,000. Where he's supposed to pay only 80, he has paid extra how much? 80,000 extra he has paid. Now, Kamya cannot pay because she has become what? Insolvent. So who has to share this balance 80,000? Krish and Ketan. So Krish will bear 40,000 and Ketan will bear 40,000. So now if you see, since Kamya has become insolvent, Krish is compelled to pay the whole amount. Krish is now entitled to receive 40,000 from. Sorry guys, I just missed it. Ketan did not pay 2 lakhs. Ketan did not pay 2 lakhs also. If you see here, Krish is compelled to pay the entire amount. Therefore, let me just explain again. So if you see, Krish paid first Kamya and Ketan. Now, actually they should all pay 2 lakhs, 2 lakhs and 2 lakhs. But what is happening here? Krish, Kamya has become insolvent only 1/5. So first she has paid, she can only pay 1/5. Krish is compelled to pay the whole amount to Diya. Let's go with the question, guys. Kamya has become insolvent and her private assets are sufficient to pay 1/5 of her share of debts. Krish is compelled to pay the whole amount to Diya. So first, Krish has paid full 6 lakhs to Diya. Examine the provisions of Indian contract and decide to the extent to which Krish can recover from Ketan. Now, correct. I'm getting answers from everybody. All your answers are correct. Just 1 second. Correct, days. So all your answers are correct. Let me just explain again. Okay. So they are saying Kamya can only pay 1/5 of her assets. So 2 lakhs into 1/5 will be 40,000. So Kamya can only pay how much? 40,000 she's able to pay. What is the shortfall? The shortfall is 1,60,000. Follow very carefully, guys. Her private assets are sufficient only to pay 1/5 of her share. So out of 2 lakhs into 1/5, only 40,000 is paid by Kamya. So balance how much she has to pay? Kamya has to pay balance 1 lakh, 2 lakhs minus 40,000, 1,60,000. This loss will be shared by Krish and Ketan equally. Krish will pay 80,000, Ketan will pay 80,000. Therefore, totally Krish has to pay 2,80,000. Kamya paid 40,000 and Ketan should pay 2,80,000. These are the numbers. Total will come to 6 lakhs. Understanding, guys? So how much will Krish will recover? 40,000 from private assets of Kamya, and he will recover entire 2,80,000 from Ketan because Ketan did not pay itself. Understood, guys? Anybody has a doubt? I'll explain again. If anybody has a doubt, just type in the chat. Sir, can you please explain again? I'll explain again in the whiteboard. Otherwise, I'll proceed. Can I proceed, guys? Okay. Conclusion, guys. Krish will pay 2,80,000. Kamya will pay only 40,000 and Ketan will pay 2,80,000. Totally 6 lakhs. Okay. So now we will just take up one last question and then we'll proceed to the doubts. Yeah. So let's take question number 3. I'll read question number 3. We'll close question number 3 and then I'll take up the doubts. X received certain goods from Y and promised to pay 60,000. Later on, X expressed his inability to make the payment to Z. Okay, sorry, X, let me explain. X received certain goods from Y and promised to pay 60,000 to Y. Later on, because X is not able to pay, Z, who is known to X, maybe is X's friend, pays 40,000 to Y on behalf of X. However, X was not aware that Z paid 40,000 to Y. Now, Y is intending to sue X for the entire amount of 60,000. Can he do so? Yes or no? So what they're asking if Y can recover entire amount from X? No. See, the concept is consideration can be paid either by the promisor or any third party. Who is the third party here? Z. So Y got 40,000. He can only claim balance 20,000 from X. So this is the answer for question number 3. So now what we'll do, we are done until question number 3. The balance questions along in the next class. Next class will be on Monday, guys. Let me first make it clear before others who can leave. Monday, we will continue these questions. This should take around 30 minutes maybe. And then we'll start with one more act, either Sale of Goods Act or Partnership Act. I will provide the videos in the link. And tomorrow, Sunday, why no class tomorrow? Sunday, we will have maths class tomorrow. Sir will be starting with calculus chapter. Now others who are done with the class can leave the chat, and now we will take up doubts. So I'll go with doubts one by one with the person who has raised their hands. First, Darshita had a doubt. I'll unmute her, and then later anybody has doubt can type their doubts. I'll unmute them, and then they can ask the doubts. Yes, Darshita, I've unmuted you.
Sir, can you please display true and false screen?
Yeah, sure. Question number?
Second. So the doubt here is where one party to a reciprocal promise prevents the other from performing his promise, the contract becomes void. So it becomes voidable on the option of the party who is being prevented, right? How is it void?
Okay, so if you take your textbook, I'll just tell you which page number.
Yeah, sure.
Just 1 second. I'll just take the page number. Just give me a moment. Correct. See, where one party prevents the other party from performing the promise, the contract becomes voidable. This is given in page number 1.69, point number 3. So the answer is false. This statement is false, correct?
Yes, sir. It's voidable, right?
Yes, it is voidable. It is voidable. Since the statement is saying the contract becomes void, the answer is false.
Yes.
Like I said,
actually, I think you had told true.
No. A to J all are false. In this set, A to J all are false.
Okay. And I also have a doubt in...
I said, okay, I'm sorry guys, if I said something, the answer is, if one party prevents the other person, it becomes voidable. So the answer for this is false.
Yes, sir.
Okay.
Also, I have doubt in F question. The death of the promisor always discharges the contract.
Yes.
Sir, how is it possible? The representatives of the deceased promisor can repay the money and then the contract gets discharged,
That's why
right?
the answer is false. I told false only.
Okay, so that is why it is false.
Yeah. Because other party can also, even the legal representative can perform, right? So the answer is false. Because there's an exception. Otherwise, the statement will be true.
Okay, sir. And sir, can you please display the third question?
Sure, 1 second. Yeah.
Sir, here Y can sue only for rupees 20,000 to X, right?
Correct.
And not to Z.
Y can sue only 20,000 to X, not to Z, not to Z. Only to X.
Okay, sir. Sir, I'm done with my doubts. Thank you.
Okay. Anybody else who has a doubt? You can just raise your hand if you have a doubt, or else I'll wind up the class. Soumya wants unit 6, question number 6. Just a moment, Soumya. Let me open the handout. Okay, so Soumya, very simple. In this question, I'll give you the answer. Explanation when I give the video, you can see it. See, they're saying A agrees to pay B 50,000 if B marries C within 1 year. State the legal positions. If he marries after 1 year, not valid. Marries within 1 year, then it becomes valid. It becomes valid. Then marries within 6 months of agreement. Valid. Sorry. B marries D within 6 months of agreement. B is supposed to marry C. D is a third party, therefore not valid. And last one, again valid because he marries within 6 months. Fairly simple. Question is if B should marry C within 1 year. Here, if wherever in whichever case B is marrying C within 1 year, it becomes valid. Otherwise, it is not valid. Okay, somebody raised the hand. Just 1 second. Let me just check. Kriti and Anu. So I think Anu was raising it first. I'll just unmute Anu. Then I'll go to Kriti. Yes, Anu. You can ask your doubt. Anu, I'm trying to. Yeah, go ahead. Anu.
Yes, sir. I had the doubt in the previous question paper.
Which unit?
Sir,
Which unit? Which unit?
and previous question.
Sorry, your voice is
Fifth,
unit 5, is it?
fifth unit, sir.
Okay, I've opened it. Which question in unit 5?
The last question, horses question.
Okay, yeah. So horse question. Yeah.
The horse also infected other horses.
Yes.
Sir, the question given is there is a warranty. But if there is no warranty, will the concept of let the buyer beware prevails here, sir?
Yes, it will prevail. If there is no warranty, then buyer beware will prevail. Yes.
Okay, yes, sir.
Okay, so next is one more.
Sir,
doubt.
I asked the doubt of 16th question.
16th question in which unit? Like
In unit 3.
unit 3 from previous
Unit
class.
3. Yes.
Just a
Yes.
second. Yeah, question 16. Yes. What's the doubt in that?
Sir, can X refuse it to pay? Because they mutually agreed.
No. Any agreement in case of restraint of trade is void. So he refused to pay. Advice why? All these contracts are void. He can continue his business. Agreements in restraint of trade is void. Only there are some exceptions.
But sir, there are mutual. Yes, sir. In the exceptions, there is a mutual consideration.
See, then even if you take dealing in, let's say, kidnap, X wants to kidnap Z. He's asking why to kidnap Z. Mutually, they have agreed. Can I say it is valid?
Oh,
Same
yes.
logic. Okay.
Oh, yes. No, sir.
That's all.
Okay, sir. Okay.
Next, I think one more person had a doubt. I'll just unmute her. Kriti had a doubt. Yeah. Kriti, you can ask your doubt.
Good evening, sir.
Good evening, Kriti. Yes.
Sir, I have a doubt in unit number 4, performance of a contract.
Question number?
I have a doubt in point, novation and alteration. Can you explain, sir?
Sure. See, I'll give you an example. Let us say A and B have entered into a contract for construction of a building, which is supposed to be completed by year 2020. This was entered in the year, let's say 2017. Okay. Now,
Okay.
the agreement had so many clauses. What will be clauses? What will be the cost of project? What will be duration of project? So many other things. Now, in this agreement, in this contract, in the paragraph, if you are going to change some small point like duration because of coronavirus, instead of 2020, we are postponing to 2022, increasing by 2 years. If I'm going to change few terms in the contract, it is called alteration of a contract. But if I am going to cancel this contract, enter into a completely new contract, canceling and terminating the old contract and entering into a new contract, then entering into new contract in place of the old one is called novation of a contract. It's called what? Novation of a contract. Therefore, this becomes novation of contract. So if you see this point, which point you asked? Point number I. So substitution of a new contract in place of existing contract is called novation, not alteration. Alteration means same contract changing few terms. Understood?
Yes, sir.
Okay. So I'll just see if somebody else has doubts. Anybody else has any doubts? I don't see any other hands raising or points. If not, we can close the class. I'll just give 15 seconds for you guys to respond. Okay. So that's it. No response. So thank you all guys for the class today. We'll again meet in the next class. Thank you.